we're going to get started for this afternoon. I'd like to begin by introducing this panel of extraordinarily talented people, and I will quickly introduce them to you. On the far side, we have Mark Friedman, who's a member of the International Dispute Resolution Group at de Beauvois in New York, with extensive experience as a counsel and as an arbitrator. Beside him, you have Stephanie Cohen, who is an independent arbitrator in New York, and she's been doing this since 2012, and prior to that was a counsel at White & Case, and has also been very active in the ICC and ICDR. Besides Stephanie is Peter Griffin, who is a founding partner of Lenzner Slatt in Toronto and one of Canada's best litigators with vast experience in commercial matters, including arbitrations and acting as an arbitrator. And in the middle, you have James Serby, who is a senior managing director at FTI Consulting and lead of their international arbitration practice, and again has huge experience in valuation of cases. Beside me, I have Ian Binney, who is a well-known arbitrator, a former justice of the Supreme Court of Counsel, former counsel in the private sector in Canada and at the Canadian Department of Justice, and has done some very high-profile, both domestic and international cases. Now, I'd like to caveat this entire presentation with the fact that in many instances, what we're about to do is for pedagogical or teaching purposes, and all of our panelists have asked that we underline that at certain points, they may be saying things or acting in a certain manner that you maybe shouldn't take as their true self. This is in some ways to make the point here. So this is how we're going to proceed today. So what I would like to do then is welcome you to, it's working, folks? The cross-examination of a, Damon, not working? Not working? All right.
Go.
Lunch we got.
There we go.
There we go. So, welcome to the afternoon session of the case known as Amazonia versus Canada. And Amazonia, just to give you a quick overview, is a U.S. incorporated company, and they have agreed with the Government of Canada to build their headquarters in Toronto, Canada. They entered this contract on December 30th of 2014, and essentially Amazonia promised to build the headquarters in Toronto and to have it fully operational by May the 30th of 2016. They also promised they would employ 10,000 or more Canadian citizens. In return, Government of Canada promised to pay Amazonia $1 million on January 30 of 2015 to help get construction and things going, and to ensure all required building, construction, and land use permits were in place by January 30 of 2015. The contract had a particular clause known as Section 12, which stated essentially that if there was a breach of a significant term of the contract, either party could tender $2 million Canadian and would then be completely discharged of their obligations under the contract. However, if it was a breach of any other clause and not of a significant term, either party was entitled to resort to arbitration at a reputable arbitration center in Canada or the United States. Now, in January 30, Canada actually did live up to its obligations and tendered the $1 million, pardon me, and advised that all permits had been secured. In February of 15th, about 2 weeks later, there was a groundbreaking ceremony, and everything looked like it was going well. And in fact, Amazonia had entered into 3 main subcontractors with ABC Architects for $3 million, DEF Engineering for $20 million, and a GHI, which was also $50 million. And pardon me, I forget what their service was. Building materials, exactly. The building began, and by March 30th, 2016, the whole project had reached 50% completion. And then on April 1st, 2016, the City of Toronto came to the site and issued a stop work order. And so everything essentially stopped on the site. The parties tried to negotiate and tried to resolve the matter, but unfortunately, they were unable to do so. And got further and further entrenched and unable to make the changes necessary or to find their way out of this. So, being unable to find their way out of this, on June 1st, Canada tendered $2 million, and the Prime Minister of Canada sent a letter to the President of Amazonia explaining that they were extremely disappointed and they were tendering the $2 million and considered themselves completely discharged of all obligations under the contract. In return, a letter was sent back from the President of Amazonia on June 2nd, 2016, saying that in fact they believed the project could conclude, that they were ready, willing, and able to conclude, and that they were holding Canada liable for the stoppage of work and the damages that resulted therefrom. And they took the $2 million and put it into an escrow account at the Royal Bank of Canada. On June 15th of 2016, Amazonia commenced an arbitration at ICSID, and that was based, first of all, on the breach of the contract between Canada and Amazonia, and secondly, on a breach of NAFTA Articles 1105, which is a breach of the minimum standard of treatment, and a breach of Article 1110, which is essentially expropriation without compensation. The parties decided they would go on a fairly fast track, and they arbitrated the liability issues first, and the tribunal found that Canada was in breach of both the contract and the two NAFTA obligations. And so it remained for the tribunal to assess damages. On June 30th of 2018, the parties filed their evidence on damages, and today the damages hearing is being held here in Washington, D.C. Essentially, so you understand the positions, Canada says that the breach was economically significant, and so tendering the $2 million was all it had to do to discharge its obligations. It says Amazonia already got $1 million, has the further $2 million, and so no further entitlement exists. They also claim that any kind of a discounted cash flow or DCF valuation is completely inapt because the headquarters was not a going concern and Amazonia had no record of operations in Canada. And finally, that there had been no mitigation or curing the default that might have allowed the project to go forward. Amazonia, of course, says to the contrary, that the stop work order was not a significant breach and that damages are owed. They claim contract damages that would reflect actual loss of $73 million and 3.3% compounded interest on this, and in addition claim NAFTA damages that would reflect the fair market value of the investment, and of course feel those should be calculated on a DCF basis. And Amazonia in particular points to its very successful U.S. track record, saying that obviously its business in Canada would be a going concern and that DCF, of course, is the appropriate method. Now, the main witness who you are going to see this afternoon is John Smith. And Mr. Smith has filed an expert report on behalf of Amazonia, and he will be cross-examined in a few minutes. I'd like to also note that Justice Binney is now acting as a sole arbitrator to assess the damages. And Justice Binney will be entertaining the testimony and making any rulings that might be necessary as of today. Before we do that, Justice Binney, maybe you can tell us how you see the role of cross-examination in international arbitration and what your expectation would be here.
Well, I think one of the surprising things to people who come to international arbitration from domestic litigation is that cross-examination seems to be a controversial topic. The European arbitrators in particular see it as creeping Americanization of arbitration, which should be clean and simple and efficient. And the people raised on this continent in domestic litigation have as an article of faith that cross-examination is the greatest engine of getting at the truth ever conceived of. So there is a clash between a culture which sees it as something of a time-wasting exercise and that it is undesirable to put eminent experts in an undignified position of showing they've contradicted themselves and so on. And on the other hand, the North American type litigators who feel that the time is too compressed and the arbitrators are far too likely to intervene on the side of the expert to extend some level of protection. So the idea here is that there will be a number of different cross-examinations on particular points. Some of them are intended to be bad. Some might just be bad. Some are likely to be good. And counsel are not going to tell you which is which. So it is extremely fortunate to have James Searby willing to play sport with counsel. I gather he enjoys a good punch-up. So that is what is going to make this work. So I think, Stephanie, you have comments as well on this rather ambiguous position that cross-examination has in international arbitration.
One of the main differences when we're talking about the role or function of cross-examination in arbitration versus litigation that comes back to the divide you were just talking about, Justice Binney, is the focus on cross-examination as a courtroom procedure. And cross-examination in international arbitration really is a different beast, or it should be a different beast, and that, I think, is where some of the dividing line is, certainly from my perspective as an arbitrator, when I'm watching cross-examinations, is seeing the advocates who treat cross-examination like it is a courtroom procedure versus those who understand what differences are at play in the international arbitration process. And those differences, I think the significant differences in the procedural context, really should propel counsel to approach cross-examination differently. Some of them are quite obvious. From an international case, by definition, you're dealing with case participants from different legal, cultural, linguistic backgrounds, and the skillful practitioner is able to adapt to that. You obviously have to approach a cross-examination differently if you're working through an interpreter than not. You can't expect to get through as much of your outline. You have to be less ambitious. You have to be much more conscious about the turns of phrase that you're using and the language. And you recognize that when you're trying to develop a rhythm, that's much more challenging to get something back and forth because you have a middleman. And so, I think that those things are obvious to most of us in this room, that you do need to be able to adapt to that. And I think Ian was highlighting some of the difference on the common law versus civil law, that the background and preferences of arbitrators certainly, and their experiences and familiarity with cross-examination are something that need to be taken into account as well. It may mean that you're adopting your tone, making it less aggressive, recognizing some of those differences in the room. But at the end of the day, for me, one of the biggest differences is not just the adeptness in dealing with those sort of diversity factors, the obvious international context, but really appreciating the procedural differences between the courtroom and the arbitration. So taking a bird's eye view of it, the dividing line, I think, really comes down to whether cross-examination is seen by the examining lawyer as a tool to make a record for argument, and that, I think, is sort of the traditional courtroom approach, or whether cross-examination is viewed as argument in and of itself. And the more skillful advocates understand that cross-examination really is advocacy in and of itself. They're displaying through their questions what the case themes are. It's apparent to the tribunal where they're headed. They're signposting for the tribunal what it is that they're focusing on, and they're aware that the tribunal has been primed with the witness statements and the expert reports and the memorials, that there's background going into it. And so it's about allowing the arbitrators to make connections in real time about what's happening, not looking forward to argument at the end of the day and expecting that you can tie the dots together. So that, I think, it really is sort of the core at thinking about cross-examination in terms of an advocacy tool.
Okay, do any of the other counsel have anything to add on these sort of introductory observations?
No, I wrote that down, though.
That's very good. It's a good start. Now, John Smith is entered the witness box, has given a declaration, and has been warned that now cross-examination is starting. He's not to discuss his evidence until the examination is complete. And Mr. Griffin, would you proceed?
Thank you, Mr. Arbitrator. Mr. Smith, we are under time constraints, so I would be grateful if you would not make long-winded answers.
Very good.
Why did Amazonia hire you? What are your qualifications?
My qualifications is that I'm an economist. I have a BA in macroeconomics. I have an MBA, that's to say a Master's in Business Administration, and in addition, I'm a chartered financial analyst. Between those three, I have a very broad understanding of economics and finance and accounting, lending me to be the ideal expert for Amazonia in these proceedings.
But you're not a lawyer, are you?
No, I'm not.
So the arbitrator can disregard all the legal opinions you've given in your report. Isn't that fair?
Well, I think it's for the arbitrator to determine, first of all, if I have given any legal opinions, and then to determine what weight to accord to them.
Well, I wanted a shorter answer than that. You've given a legal opinion that the imposition of a stop work order is not a breach of a significant term of the underlying contract. That's an opinion you've given, sir.
Well, it's my opinion that the imposition of a stop work order is not a breach of a significant term. I don't think that is a legal opinion.
Mr. Griffin, doesn't all this go to weight? I mean, clearly he's beyond his expertise, but I can weigh it.
Well, I'm glad you have the point that is beyond his expertise because it's early in the cross-examination. It was a fundamental underlying assumption of yours that there was not a breach of a significant term of the contract?
Well, it's an assumption. I don't agree that it's a fundamental underlying assumption.
Well, you say that as well, that international legal principles drive your discounted cash flow approach?
They do.
Then you use an unreliable discounted cash flow method, correct?
I use a discounted cash flow method because I think it's the most appropriate method to use in these circumstances.
Well, we'll come back to that. You say international legal principles require an assessment of fair market value of the investment had there been no breach, correct?
No, what I think I say is that the breach of the NAFTA treaty gives rise to a need for full restitution, which is a generally accepted legal principle.
Well, I suggest it's another legal opinion that you're giving. So if I take out all of your legal opinions, there's not much left of your underlying damage opinion, is there? So the arbitrator can forget about the $800 million?
Oh, no, absolutely not. The $800 million is essential to putting the claimant back in the position it would have been but for Canada's breach.
So you say you gave another legal opinion that because $2 million was paid into an escrow account, it's not paid in accordance with the contract. That's another underlying assumption and a legal opinion, isn't it? Just answer the question, sir.
No, I said that because the money was tendered by Canada but not accepted by Amazonia. If I offer you $10, Council, but you decline my generosity, how can I be said to have paid you?
So
I
let's
think
stop.
council gets to ask the questions.
Well, I viewed that as rhetorical. Thank you, Mr. Arbitrator. Another assumption you make is that the discounted cash flow method is appropriate, correct?
Yes.
And how can it be your opinion because you know it's controversial?
No, I don't agree that it is controversial.
Well, you know of the academic writing on the subject,
I'm sorry, on which subject?
on the subject of the discounted cash flow method being unreliable.
I've read quite a lot about it over the years, yes.
And so I don't have to show it to you. You know all about it, right?
I know a lot about it. I'm not sure what it is that you could show me, though.
Well, sorry, do we have that opinion? No, or I'm sorry. I'll find it later. We'll come back to it. But I say that your opinion isn't consistent with the writing in the area, and we'll prove that, but we'll deal with that later. And those authors sure wouldn't support your opinion about $800 million.
Well, I don't know what they'd say, but it was I who was asked what the opinion was and not them.
Well, let's talk about your opinion for a moment. At section 6.1 of your report, and I'm going to read, DCF is a valuation method used to estimate the value of an investment based on its future cash flows. DCF analysis assesses the present value of the investment by reference to the expected future cash flows, discounted at an appropriate rate to render them in today's money. That is your opinion?
It is.
DCF, you go on to say in 6.2, is the appropriate method of valuation for an investment that is a going concern. Amazonia had a proven track record of profitable and knowledgeable operations in the U.S., a global reputation in the industry, and would have had a similarly successful venture in Canada. In my opinion, the DCF method is the most accurate valuation method to apply in this case and will best determine the fair market value of the investment. Is that your opinion?
It is.
So you say. And as I understand it, after you get to the $800 million, you put interest on top.
Yes, I applied interest because I consider that the award of pre-award interest is standard practice and specified by Article 1110 of the NAFTA Treaty.
Well, at paragraph 7.3 of your report, you say you've been instructed to apply a rate of 3.3%.
Yes, that's right.
So that wasn't your decision, that was the lawyer's decision.
Yes, that's right.
Another legal opinion.
No, it's an instruction.
Whose opinion was it, yours or the lawyer?
Well, I was instructed to assume a rate of 3.3%, and then subsequently I noted that the 3.3% was consistent with certain evidence of market-based rates.
After the fact.
Well, around the same time as the damages claim.
And then you compound the error and the interest.
I'm sorry, could you repeat the question?
I said, then you compound both the error and the interest.
I don't agree that I did make an error, but the interest is certainly compounded.
I'm going to suggest to you that implicit in the DCF analysis is a notion of compounding.
To the extent that the forecast extends over multiple years and a discount rate is applied, then there is an element of discounting associated, yes.
No, not discounting, compounding.
Discounting is the inverse of compounding, so yes, they're flip sides of the same coin.
Yeah, well, that's what I thought. Another legal conclusion. You shouldn't be making legal conclusions, as that makes your evidence unreliable to the arbitrator.
To my understanding, I've not made any legal opinions.
Just so you know, I'm going to tell the arbitrator at the close of this case that you're unreliable.
And that may be your opinion.
Yeah, there was one other thing I wanted to ask you about. $73 million you awarded for construction costs, correct?
Correct.
And that was the entire amount of money that Amazonia paid to the contractors and suppliers of material
That's right.
and architects?
Yes.
They've got half a building left, right?
Half a billion?
No, half a building
Oh, half a building. Yes, they have half a building, yes.
and the land.
Yes.
But you don't give any credit in the $73 million.
No, I don't.
You ever heard of the word mitigation?
I've heard of it, yes.
That's what I thought. No further questions, Mr. Arbitrator.
All right. So I think the next thing is for you to explain just what it is you are attempting to do and whether it went well.
Well, I was hoping to demonstrate that a little more forethought has to go into a cross-examination than that little baby that I just delivered. And really going back to what Stephanie said a moment ago, which is your theory has to be apparent, the subjects have to be apparent, and the transition in the subject matter has to be apparent. I've always been a great believer of the fact that, first off, the best cross-examination you've ever done in your life was at 11 o'clock the night before. From there, trying to get the message across into the head of the arbitrator through a witness means that even the best organization is fundamentally diluted on its way to get the message across. So structure and approach is so important. So what I did was a jumbled up affair where I never really told anybody where I was going. I ran from thing to thing, said I'd come back to other things. And you can't run a cross-examination like that and expect anybody listening to ever be able to absorb the information. The other thing that was I tried to demonstrate was you have to pick your point as to where you deal with the credibility of the witness. There may be a point that you have to attack it. You've got to figure out what you can get from the witness before you get there. And you may never do it if you get enough from the witness. But sort of going at the witness on their qualifications at the very start really has it a bit backwards. Lastly, if you're going to try and contradict somebody on a document, it doesn't hurt to have it with you.
Mark, any comments?
Yes. A few observations on that cross. I would say it went well for James. I think but to Peter's point and picking up on something that Steph said, in terms of planning and preparing the cross-examination, if you conceive of it as being kind of a structured argument through a witness, at least when it's at its best, when you have the material to do that with, you need, and we don't have time to do it in these short vignettes, but it's important to think about how the whole thing is going to go. There's a beginning, there's a middle, there's an end. The sequence in which you put arguments matters. Often in constructing a cross-examination, I think it's good to start with something where you can win, where you can establish that you are right, that you have control over the witness, even if, and especially if it's not the most consequential point. People may not be ready for the most consequential part, especially in what will be a longer examination. You may need to build up to it. But think a bit about the kind of narrative arc of the whole thing so that you know that you're going to have the tribunal's attention, for example, when you get to the really critical or really difficult or really complex parts, and that you're going to be able to have your themes come through very strongly kind of throughout, so that the whole thing will be kind of deeply resonant in what you're doing. If your theme, one of your sort of underlying themes is that the witness is unreliable, the witness doesn't actually know what he's talking about, or that the witness has stretched beyond what would be safe for an expert or a fact witness to know about. Those are thematic things that can be illustrated and demonstrated at various points with different manifestations in the witness's evidence. And so I often think about where am I going to start, where am I going to end, because I want to end strong and leave the right impression with the tribunal, and how do I construct all the middle parts with the right kind of pace, tone, and balance so that it's appealing and interesting and it establishes the overall kind of message that we want to get out of it.
Stephanie?
Well, I mean, I think just following on what Mark was just saying, that the critical part about the preparation in order to be able to do that is to know when you can leave that outline. you have to listen to the witness. And Peter, I'm not sure that you were listening to the witness all that well, or paying much attention or trying to pick up on what the answers he was actually giving are. But that, of course, is a difference. If you're really well prepared and you have that narrative arc, then you are able to pivot and drop lines of questioning, go to other ones, but really show the tribunal that you're listening to the witness and using what the witness is saying and draw from that.
James.
For an expert too, structure is important. It was actually quite difficult to follow the lines that Peter was pursuing there, and so it's quite difficult to come up with answers that make sense in the overall context. One of the things you have to remember is that the witness you're cross-examining is under some stress, so there's probably quite a lot of adrenaline flowing, the heartbeat's racing, and although there's an impression that sometimes experts can be defensive or difficult, actually you need to help your expert to help you. And one of the ways you can do that is by constructing a clear roadmap and signposting and so on, so that the expert actually knows where you're going and can try and help you to get there. Because your objective in cross-examining is to get your case on the record, and the witness will probably be more helpful to you if you help them by giving clear instructions and signposting of where you're going.
Okay. I think one of the interesting things were the 2 paragraphs or 3 paragraphs of your opinion that Peter read to you, and you agreed that that's what they said, and then he moved on. So the result was simply to reinforce the opinion he'd already given to the tribunal. But one of the things that strikes me in these arbitrations is it's very common for lawyers to read stuff at an expert and allow them to agree with what they've already said. And I'm going to quote just a short question and answer from a recent transcript. The lawyer says in this paragraph, and I'm reading out loud, you establish clearly there are legitimate policy concerns that might lead a government to keep prices low, in particular for the most vulnerable consumers and for companies facing international competition. So, do you agree that it's a legitimate policy concern to protect somehow vulnerable consumers and competitiveness? Answer. Well, that's what the sentence says. So, yes, that's exactly what we say. Question. Very good. Now, please turn to tab 7. So it's so often that pointless questions that do nothing but reinforce. So now we go to the next vignette, and that has to do with the form of questioning. And Mark, I think it's up to you.
Let me briefly preface by saying we're going to do this one twice. So 2 short vignettes focused on the form of the question. Good afternoon, Mr. Smith. I would like to ask you some questions about your use of discounted cash flow, or DCF, to estimate damages. Okay?
Okay.
In your report, you say that DCF is the appropriate method of valuation for an investment that is a going concern.
Yes, that's what I say.
Okay. Can you explain why it is appropriate to use DCF for an investment that is a going concern?
Yes, I can. So when a business is operating today and is expected to operate for the foreseeable future, then DCF is an appropriate valuation technique to use.
And what do you understand going concern to mean?
So the only definition that I know of going concern is from the accountancy profession, and a going concern is one that is expected to operate for an indefinite period in the future. In other words, the going concern assumption in an accounting sense is that the auditor has an expectation that they'll be signing their accounts in 12 months' time.
Are you familiar with a different sense of the word in investment arbitration?
So some arbitral tribunals and some awards that I've seen seem to consider that going concern is one that has a track record of successful operation in the past, and that backwards-looking approach is at odds with the accounting definition, which is prospective in nature.
Okay, well, let's stick with that tribunal approach if we can for the purpose of these questions. At the valuation date, was Amazonia's project in Canada a going concern on that definition by tribunals?
Not by tribunals, but yes, by accountants.
Well, what was the project's actual status at that time?
So it was an incomplete building.
And what information did you use to estimate the future cash flows of Amazonia's incomplete building?
I used projections about Amazonian's operations in the United States, which I understand in future will be managed from Canada.
Well, how can you say that Amazonia's investment in Canada was a going concern when it never became operational there?
Well, I say that because it clearly had a bright future of prospective operations in the future.
But do you think it's valid to use DCF in this way on a project that never established any operations in Canada?
Well, it depends, but I believe that it would have had a successful future, and so in that case, a DCF approach can be appropriate.
Okay. Now let's try it a different way. Good afternoon, Mr. Smith.
Good afternoon.
Am I correct that discounted cash flow values an investment based on its expected future cash flows and a discount rate?
That's right, yes.
And you need a reliable basis to estimate those future cash flows, correct?
Yes.
And the cash flows cannot be merely speculative, is that right?
It depends what you mean by speculative.
Well, you would agree with me that so is it your opinion that cash flows can be speculative in order to support a discounted cash flow analysis?
Potentially, yes.
So would you agree with me that cash flows, that you would require some evidence supporting the current level and the future prospects of cash flows to make them valid for a discounted cash flow analysis?
Yes, I'd agree with that.
And that is why DCF is the appropriate method of valuation for an investment that is a going concern, correct?
Often, yes.
Okay. Now, in this case, the investment you have valued is Amazonia with a headquarters in Toronto, correct?
Yes.
But Amazonia never operated from a Toronto headquarters, correct?
No, it never got that far.
Or from a headquarters anywhere in Canada, so far as you know, correct?
That's right.
Okay. Now, the investment that you've been asked to value, the Canadian headquarters, therefore had no history of generating positive cash flows, correct?
Not from the headquarters in Canada, no.
So any future cash flows about what would happen in Canada were speculative in the sense we discussed before, correct?
Yes.
Okay. According to your expert report, the only financial information you reviewed about Amazonia was Amazonia's annual financial reports from 2012 to 2018, correct?
Yes.
And those reports did not show any track record of financial performance of Amazonia operating with a Toronto headquarters, correct?
No, they didn't.
Those reports showed a track record of Amazonia operating in the United States with a U.S. headquarters, right?
Yes.
And that track record showed that Amazonia makes revenues of more than $15 billion a year from its U.S. headquarters, correct?
Yes.
And nothing Canada did deprived Amazonia of that U.S. headquartered business and the associated revenues, correct?
No.
Okay.
Can you just explain whether you looked into the penetration of Amazonia from the United States into the Canadian market?
In essence, I was saying that the Canadian headquartered business would be similar to the one in the US, and that without the headquarters, then I assumed that the business would also fail.
Right. And do you think those assumptions are reasonable?
In my opinion, yes.
Mark, why don't you, apart from the unhelpful interventions by the arbitrator, explain what you were doing and
Right. So those two approaches to essentially the same topic were designed to focus on the form of the question. And they illustrated, on the one hand, using open-ended questions, which I think of often as taking a deposition of a witness rather than actually cross-examining them. And the second one was a very tightly controlled cross-examination in which every question was a leading question. And through that, hopefully it became clear that the first one credentializes the witness. It allows the witness to be professorial, to go to the areas of his or her best knowledge, and to come across as, quite valid. It gives them a lot of freedom in which to roam and to basically pick the expert's own spots. Whereas the tightly controlled one focuses, hopefully like a laser in a rifle shot sort of way, on the particular weaknesses that you want to exploit in what the witness is saying. And it allows you to kind of stay in control and lead where you're going. Now, it should be, the tightly controlled one should be more effective. What I have often found, though, is it's amazing how tightly controlled you need to be tightly controlled, in the sense that even a little bit of allowing the open-ended questions during the course of an examination can change the dynamic quite a lot. And you can go along, and if you're doing 2/3 controlled and 1/3 of open-ended, it's going to give the impression that the expert really is owning the stage and saying what he or she wants, or the witness. It's true with fact witnesses as well. And so it requires, I think, a lot of discipline to really stick with it, especially in a longer examination, to really stay on top of it and keep the witness buttoned in. So that's what we were trying to illustrate through those vignettes.
Okay, Peter, Stephanie, any comments? Peter first.
Well, you just see the power of a leading question. We lose our way as counsel when we don't ask leading questions in cross-examination.
Stephanie?
So one of the things that always strikes me in the tightly controlled cross-examination is being able to take a step back as counsel and not make it too tightly controlled. The arbitrators, again, having prepared, hopefully are familiar with what's going on, but are not going to be as familiar as either counsel or the witness. And sometimes when counsel gets into that good rhythm, it's a little bit too much of a rhythm, and it can go a bit too fast. And I think it's important to make sure that the tribunal is staying along with you, especially when you're cross-examining the expert witnesses, because you want to make sure that train of thought is being followed, and that the sequence back and forth is not going so quickly that you lose track of the arbitrators. The second thing, of course, about that questioning is, the arbitrator jumped in at the end to ask the question that he wanted to ask, and that's the huge difference between the courtroom versus the arbitration hearing room, which is you can try and control the witness, but you can't control the arbitrators. And so being cognizant that the arbitrators may intervene and being able to come back to your outline and stay in control of where you want to go, being responsive to what the tribunal has done is something that really the skillful advocates can do well, and others get flustered by.
Just two comments. One is, I think many arbitrators resent a tightly controlled cross-examination. If they've got a witness who they think is a legitimate expert who's got something to say, and they sense that there's some unfairness about boxing the expert in with these very tight questions, and I think they're apt to jump in with something like, well, let the witness explain that. So you have to be careful not to go too far. The other thing I think is interesting is that, unlike a judge who's got the power of the state behind him or her, the arbitrator is simply there on consent. And intervening inevitably tilts the cross-examination or the submission. And you have to be very careful, I think, as an arbitrator, not to be seen to be tilting it, even though the intervention could be perfectly legitimate and would be not at all surprising from a judge. So there are these differences that keep emerging. So we move to topic number 3, and Peter is going to take up his cudgel.
So the title of this vignette is One Question Too Many. Mr. Smith, the discounted cash flow method involves establishing future cash flows and then discounting them to the present using a discount rate.
Yes.
That creates a present value.
Yes.
And the size of the discount rate, if I can call it that, affects the result. The higher the discount rate, the lower the value, and vice versa.
That's right.
The discount rate itself is made up of a number of components.
Yes.
The first is a risk-free rate of return,
That's right.
to which is added an equity risk premium multiplied by a beta.
That's right.
And we'll come back to beta at one point. But there are also other risk premiums that can be included in the calculation of a discount rate.
They can be sometimes, yes.
Right. Such as a size premium.
I have seen a size premium, though I don't agree with it personally.
I'm sorry, I didn't hear the last of that. I was just concentrating on my next question.
I have seen size premiums used, but I don't agree with them personally.
There is also something called a company-specific risk premium.
I have heard of such a thing, yes.
But I wanted to come to one more, which is called a country risk premium.
Yes.
And you understand that is a premium that would be added to the discount rate, risk-free rate, equity risk premium, and beta in order to reflect country risk.
Yes.
And nowhere in your report do you address country risk premium, correct?
That's right.
And you never formed an opinion on country risk premium, did you?
Well, I didn't think I needed to. So my understanding is that Canada is a mature, developed country, and then as such doesn't require a country risk premium. In effect, its country risk premium is zero. And if you look at the published work of Professor Aswath Damodaran, I think you'll find that the country risk premium for Canada is indeed nil.
Is this before or after President Trump?
Wow. I think we might be talking about a country risk discount. Yeah.
So I'll come to the second vignette, which is called Leaving Room for Reexamination. And so I'll carry on with that one. In approaching your valuation exercise, Mr. Smith, you have concluded that Amazonia had a proven track record of profitable and successful operations in the United States, a global reputation in the industry, and would have had a similarly successful venture in Canada.
That's right.
I take it you have never operated a business similar to Amazonia?
I have not.
I think you indicated earlier that you had not prepared you had not worked from any cash flow projections provided by the company for a Canadian operation?
No.
Your expertise is in valuations, not operations.
That's correct.
You have never been a chief financial officer of an operating business.
No, I've not.
And you agree that there's no analysis in your report that you can show to the arbitrator sitting here today to back up your conclusion about a potential successful venture.
No, I don't agree.
May I redirect?
Why would you want to redirect other than to change answers he's already given?
Well, the very last question, I think, opened the door to find out what support there is in his report. He was asked directly about whether there's any analysis that he can show to the arbitrator, and I think he just should be allowed to expand on that.
With
right,
respect,
go ahead.
Mr.
Sorry.
Arbitrator, this smells like a case split to me.
Counsel opened the door.
Well, counsel opened the door, and cases are split all the time, so proceed.
Mr. Smith, you were just asked about whether there is any analysis in your report that you can show to the arbitrator to back up your conclusion about a potential successful venture. Do you recall that?
I do.
And you answered that you did not agree with that question, correct?
That's right.
And can you explain to the arbitrator why?
So in my report, there's a description of the DCF valuation approach and how I've reached at my conclusion of $73 million in damages for the building and $800 million for the business. And I don't agree, therefore, that I didn't have any analysis in my report.
Thank you.
All right, anything arising out of that, Mr. Griffin?
Not so as you'd notice.
Okay. So can you explain what you were up to, and then we'll get other comments?
Well, the temptation always in the cross-examination business is to go too far. And I got him to the point in the first vignette of saying, nowhere in your report do you address country risk premium. That would have been enough for me if my expert had expressed an opinion on country risk premium. I would have kept this witness out of it and I would have had my evidence occupy the field. But not being content with that answer, I had to ask the next question, which gave him an opportunity to say, no, I do have an opinion on it. And now I'm no longer tied to the report, whatever his evidence in chief is in whatever form it took, report, affidavit, whatever. And now I'm in a position where I haven't got much to work with because the cat's out of the bag. So it's a nice prescription to say don't ask one question too many. It's a little more difficult to deliver when you're actively in the middle of a cross-examination.
Easier to judge in hindsight.
James, you wanted to jump in?
Yeah, I did. So one of the skills of being an expert is the objective is to help the tribunal, and one doesn't help the tribunal by constantly rabbiting on, even if counsel does ask a lot of open questions. So even if the questions are open, it helps to keep the answers reasonably brief. But when you're being tightly controlled under cross-examination, the skill is knowing when to break away from that and seek to give a fuller answer, and when it would be appropriate to break the rhythm of the cross and try and get away from the tight control of counsel. And if the cross-examination stops one or two questions short of where you expect it to go, then you may lose that opportunity. And that's another strength of trying to keep it tightly controlled and back. So by all means, pass the ball up the field, but you don't necessarily have to, kick it into the goal. You can stop before then and still have made your point and keep the expert more under control.
Mm-hmm. Mark, Stephanie, any comments?
I think the thing about reexamination most of the time is really whether you should bother to reexamine at all, just when to walk away and leave things as they are. So that's, when it's most useful, I think, is when there's something fresh in the tribunal's mind. So if it is one of the last questions, then those tend to be things that are good to go for. But if you have to go way back and you're working through to try and hit all of the different points, I think you have to think about whether it's worth doing that.
I think also that re-examination, I know that you're not allowed to ask any leading questions on re-examination, but you'll probably be dealing with an expert that's a bit punch drunk, in addition to the adrenaline and all the rest of it. And actually, it can be difficult to get a good answer in re-examination because you're not allowed to signpost, and the expert may not remember exactly what they said half an hour ago anyway.
Right. Yep. If I could offer just one comment on each of the 2 points. One is the asking one question too many, and this example, Peter's great example of it was, is probably an illustration of the old adage that you never ask a question on cross that you don't know the answer to already. And beyond that, that you don't have some kind of control for. So here, Peter had good control over the idea that, that Smith didn't address in the report the question of country risk, because it's not in there, it's objective. You could ask him to look through the report and find where it's addressed, and he won't be able to. But he didn't have any control for the idea about what, if anything, Smith's views about country risk may be. And so you always expose yourself if you are going beyond something that you have really tight control over in the form of some kind of impeachment. And then on redirect, I do think it's challenging a lot of the time because the context is different. You may have had a conversation with the witness previously, and 10 times the witness has told you about a set of facts or a particular opinion, and then on the stand, people are under pressure. You ask the very same question, and you get a weird and different answer, and what do you do with that, and how do you rehabilitate when you can't lead? One of the things that I try to do to sort of control that is to kind of lead without leading in a way, and it goes back to the point that Peter was illustrating in the first vignette, but even in a redirect, at least a slightly longer one, if you can give the witness a framework, a structure, get their mind focused on exactly what the question is or how it fits in, maybe with documents or what the witness has said previously, it at least gives the witness a fighting chance, I think, to get his or her head back to the right place.
Yeah, it strikes me a couple of things on re-examination. One is there is an opportunity for an answer to which the other side has no opportunity to break down. So that's the last thing the tribunal hears. The other problem, though, is that quite often the expert is quite frustrated by being controlled and lets loose on re-examination beyond the bounds of the question and emerges as an advocate, not as the expert witness. And I think that happens a lot in these arbitrations.
Yeah.
All right, James, anything to add to your earlier comments? Are you ready for the next bout?
I am.
Yeah, I think they're going to use it
Closer.
All right, vignette 4, Mark.
Yes, this vignette is about credibility. Mr. Smith, you say that you've been asked to provide an independent opinion, correct?
Yes.
And that is based on your professional assessment, right?
Yes.
And your profession is economics, correct?
I'm an economist, yes.
All right. Now, Section 12.1 of the contract between Amazonia and Canada contains a liquidated damages provision. Is that correct?
That's my understanding.
Okay. And we looked at it before on the screen, but do you remember that Section 12.1 provides that where there is a breach of a significant term of the contract, the breaching party can pay 2 million Canadian dollars to achieve a full and complete discharge of both parties' obligations?
Yes, I think that's what it says.
And you are aware that Canada, in fact, tendered 2 million Canadian dollars to Amazonia, correct?
My understanding is that the money was offered by Canada but not accepted by Amazonia.
Now, in your expert report, you would express an opinion about this Section 12.1, correct?
I'm not sure what you mean there. Could you take me there?
Sure. Do you have your expert report in front of you?
Yes, I
Could
do.
you turn to Section 5.2, please?
I'm there.
And in Section 5.2, you say, in my opinion, Section 12.1 of the contract does not apply in these circumstances. Do you see that?
Yes, I see that.
Okay. And so you indeed offer an opinion about Section 12.1, right?
Yes, okay.
Okay. And what you say in particular is that your opinion is that Section 12.1 does not apply because the imposition of stop work orders by the City of Toronto is not a breach of a significant term of the contract. That's your opinion, correct?
Yes.
Okay. So you express an opinion about whether Toronto's stop work order was a breach of a significant term of the contract, right?
Yes, I express an opinion as an expert. It's
And
my
in your
judgment.
written expert report, you do not explain the reasoning behind your conclusion that that was not a breach of a significant term, correct?
No, it's a matter of judgment. It's my judgment as an expert that it was a breach.
But you don't explain the basis for that judgment in your expert report, correct?
Not in detail, no.
Okay. Now, the tribunal has already held that Canada breached the contract with Amazonia, correct?
Yes.
And so your opinion must be that this breach just wasn't a breach of a significant term of the contract. Is that right?
That's right. It wasn't a breach of a significant term.
Even though, in your view, that breach prevented Amazonia from building a new headquarters and cost it $800 million in damages?
That's right.
Okay. Now, your opinion about Section 12.1 is actually very important to Amazonia, is it not?
I don't know. I don't know what you mean by important.
Well, if there was a breach of a significant term, and Canada in fact paid the required liquidated damages, then that would discharge all of Canada's obligations, right?
That's what the contract says.
So, and your testimony about Section 12.1 therefore helps Amazonia access damages beyond the liquidated damages, correct?
Yes, it does.
Okay. Now, you are an experienced witness, correct?
I am.
And you specialize in the assessment of quantum issues in contentious matters, correct?
Yes.
And you have testified in more than 70 times before courts and tribunals, correct?
I have.
And in just the past 3 years, you've testified 30 times in investment arbitrations, correct?
Yes.
So that's nearly once per month testifying in an investment arbitration,
It's
correct?
been a busy 3 years.
Well, that's busy enough to be basically full employment as a testifying expert, correct?
That's my full-time day job, yes.
Okay. Now, you are a particularly experienced witness for Amazonia's counsel, isn't that right?
I don't know what you mean by particularly experienced.
Well, Amazonia is represented here by Ms. Cohen, correct?
Yes.
And Ms. Cohen has, in fact, hired you as an expert witness at least 15 times in just the last 3 years, correct?
I think so, yes.
So half of your full-time employment over the past 3 years has been for Ms. Cohen, correct?
Yes.
And Ms. Cohen has been a significant source of business for you, obviously, during that period.
We've had a successful track record together, yes.
And you would like to be a significant client, a source, you would like her to be a significant source of business for you into the future, correct?
I never like to lose a good client.
Right. Now, you just didn't disclose, though, any of those facts in your report, correct?
No, I didn't.
Okay. No further questions on this line.
All right. How did you feel about that, John? What was your reaction to that line of questioning?
Well, I thought it was very effective. If I'm ever asked to agree with an adjective as an expert, I'll probably never agree to it. Mark and I were talking about this over lunch, and I said, well, I'll never agree, to a characterization using adjectives as an expert. But Mark said, well, I find it helpful to get these things on the record, and it doesn't really matter whether you agree or not.
Right. Right.
And well, that was a point of debate. Mark? What do you
Yeah, there were kind of a couple of things that we were trying to illustrate through that, and credibility is sort of actually a bit of a tricky issue, I think, to deal with on cross-examination. So just a couple of observations about what we were trying to analyze and illustrate. One was often credibility, think if I just started with the credibility piece of that, right, which was the idea of you got hired a lot by somebody, and then I got to the substance. Credibility by itself, I always find, is a bit sterile. It doesn't answer questions. It may be that the witness has some partiality, but the witness may nevertheless have a lot of very valuable stuff to say, or otherwise be highly credible, and you give the person an opportunity to kind of rehabilitate him or herself. So I often sort of reserve credibility issues and think about, as I'm going along, maybe I put them more towards the end or whatever, because I want to be sure that I engage on the substance first. So we have limited time, but the idea of this small vignette was to sort of set up the idea that he's giving a kind of stretch opinion on what ought to look a lot like a legal subject rather than something in his core area of expertise. And you might be wondering, well, why is he stretching about this, whether it's a material term or not, especially in the incredible circumstance where he says this breach cost $800 million. How can it not be material? And then you kind of, that hopefully raises a doubt in the tribunal's mind about why this well-qualified person would say such a thing. And then you kind of give the answer by saying, well, look, there's this element of sort of partiality and shading that ought to trouble you. So while the credibility attack wouldn't be disqualifying, it does sort of end up being reinforcing of some of the substantive attacks you're making. The second thing I want to point out very briefly is, and as James was just mentioning, kind of in the middle there, I asked him these questions about, well, this testimony you're giving is important to Amazonia. It's not really his business to say whether it's important or not, and I don't care what answer he gives at that point. I'm simply trying to sort of set up the argument and use it, as Steph was saying at the beginning, a little bit of a kind of signposting about where I'm going with the argument through the witness. Those are questions I don't care what the answer is, because the answer is a little bit obvious. I can always go back on it if I need to, and so it's just basically a kind of road marker along the way.
I think the other thing about credibility, sorry to interrupt, is that it's something that is best treated lightly. I once saw a colleague of mine cross-examined about his credibility and whether he was a hired gun or not for about 45 minutes, at the end of which counsel said no further questions and sat down. If I feel that counsel's coming at me heavily about a point of credibility, or whether I'm a hired gun, or whether I've done this a lot or something, then I'll tend to take comfort from that they haven't got too much about the facts and the law or my opinion, if they're going at me so heavily about credibility. That said, I mean, if you lightly get your points on the record about credibility, then I think it can be very effective.
Okay. Peter?
The only thing I was going to say was you saw at the end of that cross-examination that Mark didn't get into an argument with the witness. I mean, the temptation is then to state the ultimate conclusion to the witness, and then it really devolves into a fight. The key was to leave the thought in the mind of the arbitrator about the partiality without debating it with the witness, because once you devolve to an argument, it's very hard to extract yourself from that in a way which is going to really maintain the ground that you'd already gotten to.
So the issues of credibility and impeachment are kind of in the same area of the field. What's your approach to a witness on those issues?
On impeachment?
Impeachment, credibility, when to move, when not to move, when
Well,
there's a problem.
I mean, we can't forget that an expert is, by definition, to be independent and to be there to assist the tribunal. So very often you find that you actually get more out of the witness than you expect you're going to get by virtue of the fact that they recognize the degree of independence that they should have. So going at them early on the credibility point, as we chatted about a little earlier, can be self-defeating. You may make the decision at the end of the day that you like what you got better than what you're going to get by taking them on their credibility. So maybe you'll leave that to the end and see where you are. You may get to a point in the course of the cross where you realize that there's nothing you can salvage from it, and you might as well go after them on the credibility point. But impeachments, if there's something you really need to demonstrate that the witness has said it differently somewhere else some other time, then that is one that's always worth pursuing. It also tends to tame the witness a bit.
Okay. Stephanie?
Yeah, I think on the credibility is that a lot of the time the attack on the qualifications can be quite weak. I mean, this was sort of a strong scenario, the number of repeat times, so it's sort of a softball kind of line of attack. But particularly if you're sitting in a room where the attitude towards cross-examination is perhaps lukewarm with the tribunal, I think you do have to be very sensitive to treating the witness fairly. And if counsel is coming out swinging from the outset, then they're not going to appreciate some of that line of questioning as much as I think as Mark's suggesting. If you want to make that point, you slide into it after you've sort of gone through some of the substance, and then the tribunal can kind of see the linkage between where the weaknesses are on the substance and the credibility, rather than just taking qualifications, credibility as sort of a line of attack at the outset. And the assumptions is really the key thing for addressing the expert analysis.
Yeah, years ago, a boundary dispute between Canada and the United States over the Gulf of Maine, and this was at the ICJ, and Canada had to cross-examine a professor from Harvard who was one of the world's leading experts in oceanography and movements of fish and so on. And he was saying that the movements of fish happened to correspond with the boundary that the United States was asking the court to draw. And E. Fortier, who many of you know, was given the task of cross-examining this eminent expert, and essentially showed document after document after document which squarely contradicted what the expert said in the case. We thought it was tremendous. We found out later that the judges were shocked that this eminent professor should be contradicted publicly in the formality of a court hearing. They thought was outrageous. Who knew? But that was the attitude. So moving along to vignette 5. I think, Peter, are you up to bat?
I'm up to bat, and this is impeachment, so I hope that you aren't shocked by my attempt to impeach this witness on something he did previously. Mr. Smith, I would like to turn to your use of the discounted cash flow method to arrive at your opinion on damages. And you applied, of course, the discounted cash flow method to arrive at the loss that you attributed to the breach of NAFTA.
Yes.
And you say that would put Amazonia in the position it should have been but for the breach.
That's right.
And I wonder if I could ask you to turn in your report to section 6.2.
Okay, I'm there.
And you say in the first sentence that discounted cash flow is the appropriate method of valuation for an investment that is a going concern.
Yes.
And you and I would agree that essential to your opinion is the notion of going concern.
Yes.
You and I can also agree that as of March 1, 2016, this facility was only half complete,
That's right.
2 months from the date that it was to be fully complete and operational.
According to the original project plan, yes.
Correct. And of course, Amazonia had not completed the building by either March the 30th or May the 30th, correct?
That's right.
It is a half-complete building as we sit here today,
That's my understanding, yes.
hardly a going concern.
Perhaps in your opinion.
Secondly, there were no employees hired to work at this head office,
No.
not at the end of March of 2016, not at the end of May of 2016, correct?
That's right.
And not today, right?
That's my understanding, yes.
Hardly a going concern.
Depends whether you're looking backwards or forwards. It hasn't been in the past, it may be in future.
Well, either backwards or forwards, I suggest to you. There isn't much there by way of a going concern. Additionally, you and I can agree that a building code is a public safety regulation or regulatory structure.
Inter alia. Probably there are a number of different objectives for building codes.
Well, one of them is that a building code being of general application would regulate the safe construction and operation of a building, correct?
That may well be one of the objectives, yes.
That certainly sounds reasonable to you, sir.
I'm not really a construction expert, but I'll agree with you, yes.
And our so-called going concern was not able to comply with basic public safety regulatory structures, correct?
That's the contention of the City of Toronto, yes.
I see. There were no prior operations based in Canada?
By Amazonia? No, I don't think so.
No financial statement or other performance metric demonstrating a track record in Canada for this business based here?
Not that I've seen.
Right, so neither on an accounting definition or an ordinary course definition was there any track record that you examined for Canada?
No, there was no past track record, correct.
No track record at all, sir.
No past track record, correct.
And notwithstanding that, as I understand it, it is your evidence that the Amazonia had a proven track record of profitable and knowledgeable operations, and therefore the discounted cash flow method would be appropriate.
Yes, those operations were in the United States, and they were both successful and profitable.
What I would like to ask you about, sir, is some work that you undoubtedly gave to Ms. Cohen, which is the report that you prepared in an NAFTA arbitration that subsequently became a matter of public record over the privatization of a national airport in Canada. You delivered a report in that respect over the cancellation by the Government of Canada of that airport redevelopment project.
Yes,
And that was an airport redevelopment project in which the airport developer was claiming damages for a 60-year term of a ground and airport lease executed but canceled before they took occupancy.
if I recall correctly, yes.
Right. Never in possession at all.
That was my recollection, yes.
No cash flows.
At that time, no.
No employees.
Not prior to that time, no.
You prepared a report for the Government of Canada.
I did.
In that report, you addressed the proper approach to value that loss.
Yes.
Let me show you that report. And page 2 of that report, sir, the conclusion you expressed was that the discounted cash flow method was not appropriate in those circumstances,
Yes, that was my opinion.
in the very circumstances I described to you a moment ago as to the state of development, track record, cash flows, employees, and operations.
Yes.
You said that the discounted cash flow method in those circumstances would not be an appropriate method upon which to value the project.
I did, yes.
And I take it that your view in that respect would have been that, that the DCF approach was not appropriate because there were neither stable nor predictable cash flows in order to discount, correct?
That was one of the reasons.
Right. And I take it that this report is not in the record because you chose not to provide it to Ms. Cohen?
I didn't think it was appropriate or necessary to provide it.
And, sir, I'm going to suggest to you that, like the DCF method, your opinions are neither stable nor predictable.
There's no reason why either should be stable or predictable.
Those are my questions.
It's the nature of both DCF projections and independent testimony.
I know. Stop.
Apparently, the issue does not appear to him now as it appears to have appeared to him then. Comments? First of all, John Smith.
I felt quite tightly controlled on that. I could obviously tell where it was going as an expert. It's very difficult to wriggle out of that kind of thing. It makes you look very shady. And obviously, one wouldn't ever wish to be in that position publicly.
So moving down the row, Peter, what were you trying to accomplish, and did you?
Well, I hope I did. What I was trying to do was to demonstrate that in a very similar circumstance, the valuation approach had been discounted, if you like, by the witnesses not being appropriate. And again, I wanted to resist getting into an argument because I'm not equipped to get into an argument with somebody who has done that many jobs for Amazonia. So I'm not going to win a debate. I need to make the point and I need to move on, and I can't give them an opportunity to then tell me the 15 reasons why in that report something was different than the circumstances I'm dealing with. So you've got to get to the point where you make the point, and then you've got to get out before you get into the debate, because otherwise you just go down that rabbit hole and it's hard to get out of it.
Stephanie?
Well, I didn't object to the use of the document that's not in the record being tendered to the witness, but that, of course, ends up being a big issue if you want to put something to a witness. Assumptions about what you can do to impeach credibility are not the same across the board. So for both counsel and arbitrators, it speaks to the importance of clarifying what the procedural directions are for the cross-examination. And it's not just documents, it's also things about discussions between breaks. Can you communicate with counsel? And so some of the things that we might assume if you're, practicing here are, the basic ground rules for how the cross-examination is going to take place. You can't assume that in the international arbitration context. And of course, to put yourself in the best position would to know as counsel to have set out and asked the arbitrators and make sure that's clear beforehand that we're all on the same page about what can be used to impeach or what communications can be had during the course of the communication, of the cross-examination, and to make sure that's clear. And as the arbitrator, of course, I think there's an interest in doing that as well, because otherwise somebody does object, somebody gets upset, and that's not something that you've clarified in advance, then that, puts you in a bit of a pickle to try and figure out which is the fair way to go.
Mark?
Yeah. It's awfully nice when you have sort of impeaching material like that. And it's a real gift, but figuring out sort of how great a gift it is and how to use it and exploit it to its maximum potential are the tough questions. I think that you do have to worry that everything you do can be undone on redirect. If that report, for example, had some detail to it that said, in this case, this circumstance, I find that it's not appropriate to use DCF, but that would be very different if the operator had a long track record of established operations elsewhere that were the same and not subject to different regulatory requirements, like an out. Then it would almost look like a prior consistent statement rather than a prior inconsistent one, and everything you do could be undone. That said, if you have, you really have thought it through and you can answer all those questions on, by probing further, then you can make more of it. I think it's a very dramatic moment, especially in our field where so many cases and evidence that's given is confidential. So you don't often have the prior, you might know the witness has testified 30 times or more, but you're not going to have access usually to 30 transcripts of that testimony. And so when you do have it, and it can be quite powerful. I mean, here there's an opinion about whether it's appropriate to use DCF in the circumstances, and the guy was on record in a case where his client's economic interests were the opposite way, and he gave the opposite opinion, and they're irreconcilable. And I might even, double down on kind of the drama of that moment of saying you are caught in something that cannot be reconciled.
Okay, thank you very much. I think we have some time for questions from the floor. Are there any volunteers? There's a microphone sitting there. Yes.
I wanted to ask a question about something that you mentioned before, basically repeating sentences that are already in the report or in some other documents. And it goes to this examination of technique of basically taking the witness through the record as it stands. It's not so much applicable for experts, but more for fact witnesses. And it doesn't even sometimes go to contradicting something the witness said, but it just goes through the whole story through taking it through the documents. And I was wondering if this panel thought that technique is effective.
For my part, I think counsel insufficiently consider often whether there ought to be any cross-examination, and that very often you should just leave it as is and move on with the hearing, because there's too often a temptation to say, well, I've got this witness statement and I really ought to go through it with the witness because this is my job as the opposing counsel, and you just reinforce everything the witness has said. So I think the advice is to be brief and be gone, and let the hearing continue. Any other comments on?
Yeah, I think the other piece about going through all of the documents, again, in part, is the courtroom versus the hearing room difference, because in an international arbitration, generally, most of the documents are going to be admitted into evidence. You don't have to establish the authenticity of the documents. You don't have to go through them in the same fashion. And one of the risks in going through all of the documents and is to make sure that the tribunal stays with you. And one of the things that you don't get, and again, this goes to the speed thing that happens, is when you get a lawyer who wants to go through all of these documents, and next thing you know, you're speeding along through the documents, and if you look to the left and you look to the right at co-arbitrators, is they're not on the same page, and they haven't paid attention to where the arbitrators are. And a risk of leading the arbitrators through the documents is they may have looked at things before, but now that you're asking a question about it, they want to read the document, they're interested in it. So, you can really lose track, and you may not realize, especially if you're not making eye contact with the arbitrators and watching what they're doing, that they're not at the same place as you are in the cross-examination, because they're still reading that document that you were, 3 documents back.
Mark, you had your light on there? Is that just being ready?
I think higher powers than me had turned my light on.
Okay. Next question.
Well, it's not exactly a question. Let's see. First of all, congratulations to whoever designed this program and to our panel. It's a very entertaining way to learn. I'm sitting here next to another arbitrator with whom I've served in the past, and if you don't get some of the fun out of watching arbitrations, you're missing a big part of the experience. The panel here described at the outset the sensitivity around the different views of both sides of the ocean, and sometimes the same side of the ocean, as to how cross-examination should be conducted. And indeed, there was that sensitivity, with Americans having that reputation of going right in the witness's face and being very rude and disrespectful. So it was particularly fun to watch the lead counsel for the claimant in a case, in an ICSID case, ask some of the formal questions, kind of establish the groundwork, and then the follow-up for the cross-examination was done by a very feminine young lady with a very mellow voice, whose questions were like a jackhammer. They were just, every single one was exactly like that, but always in the most, quiet and so forth. The arbitrators were in stitches. Not on the bench, of course. Thank you.
If I could just say one thing, I think it's a very interesting observation, because I see it a lot with other colleagues, in cases that we do. And one thing that I always encourage more junior colleagues to do is to watch others to learn how they approach it, but then you do need to develop your own style. Because I think as an examiner, you have to have, and as a lawyer generally, you need to have integrity. And you won't have integrity if you're trying to be someone that you're not, particularly in cross-examination. And so you're quite right that people should figure out how to use the tools of cross-examination, but within the framework of their own sort of personality, approach, and develop their own style.
Excellent.
So find your own voice, I think, is the message. Next question.
Thank you. These vignettes prompted a thought that actually none of the vignettes illustrated. However, they prompted it. So we had a very self-disciplined, in my judgment, witness, very experienced and professional. Now, maybe not as often in expert witnessing as in fact witnessing, we have a witness who wishes to elaborate at considerable length that in some degree or another appears to examining counsel to be, an opportunity to engage in advocacy. So none of the vignettes illustrated that scenario. But frankly, of all the questions that were raised from an arbitrator's point of view, that's a scenario of great interest. On the one hand, how much to shut down the witness when you really don't know yet what the witness is going to seek to say, and at what point do you start disallowing the witness? Again, this was not a vignette that we were treated to, but I wonder if it's permitted to ask a question that the vignettes prompted in me, even though none of them entailed it.
Red lights going on all over the place.
I think the controlling the witness question, of course, one of the most difficult things that arises. Starting from the counsel perspective first, I mean, when Peter at the outset, we weren't getting long-winded questions, but he said, some things about that's not the answer I was looking for, and he was a little bit gruff or abrupt. The counsel that I've seen be most effective, I think, with the long-winded questions when the witnesses are really going off the rails, let the witness go through their answer, pause, wait, are you finished? Thank you. Why don't we get back to the question that I had asked? And then repeat the question. In a much, they're respectful, but that they don't have to intervene. I think if for the tribunal, when you're watching this unfold, is that more often than not, counsel ends up intervening first, and they look for help to the tribunal. And I think in those instances, sometimes it's because the questions have not been asked very well to begin with, and it's asking counsel that it might be helpful to rephrase, the question or go a different route.
Yeah. If I could add, I agree with that very much about the being a little bit patient, even as it's enormously frustrating as counsel to let it happen. And sometimes I've even said, do you remember the question? Because after a long answer, the question has gotten totally lost, and that makes the witness feel a little abashed. But I think it becomes a balance. If the tribunal feels that the witness is just struggling to answer opaque questions or to really fulfill the job of a witness with some integrity, that's okay. But if it looks like a stall, right, so I think that's the balance that you have to, and as counsel, you will want to try to encourage the arbitrators to see it as a bit of a stall by putting down a marker and by establishing from a very early stage, look, this seems to be, we're using my chess clock, and I have limited time to ask these questions. I asked a very precise question. Can you ask the witness to focus on it? I found the first time I make that objection, I lose. But I'm only going to win it the third time. But to get to the third time, I have to do it the first time.
Sometimes it helps to explain to remind the witnesses about the way that this process works too, I think, and some of that is a bit of patience, is to remind them what would be most helpful to the tribunal is really to, allow the lawyers to ask the questions. We want to hear what you have to say. That's why we, have your witness statement while we're doing this. But what's going to be most helpful to us is if you could try and stick to the questions that you're asked.
From the arbitrator's point of view, it's not very often that disallowing a question makes sense. First of all, most of them aren't that dynamic or, either way. Secondly, I think a lot of these objections are inside baseball. I mean, you're sitting in a tribunal and an American lawyer stands up and says, asked and answered. Nobody in the room understands what they're talking about. Or they will have one question, well, I object on solicitor-client privilege. And then the other lawyer said, well, I'm relying on the crime exception to solicitor-client privilege. And I'm sitting between two international law professors who have never run into it in their life. So, it just slows everything down, and I think deserves the criticism of sort of not over-Americanizing, but putting too much emphasis on litigation techniques. Anyway, thank you for the...
Thank you.
Yeah. Yep.
Reading and rereading the information that was sent last night, I thought one point would be brought up more strongly by the respondent, in this case, Canada. And that point is that it is axiomatic that the securing permits, building permits in accordance with the laws, regulations, and ordinances is the responsibility of the owner and its consultants. I think it was alluded that Amazonia did not live up to that. And my wonder is, why wasn't that point brought up? In fact, if Amazonia was not able to secure those permits, aren't they in violation? Aren't they the ones who were at fault? And in this case, they have to pay the $2 million.
Any comment?
Well, the one part about this story that you had to deal with was that there had already been a liability phase that had been decided against Canada. So it was a question of how much you could use the failure of Amazonia to fulfill its obligations. I used it on the going concern approach to say if you can't even comply with a building bylaw, you're hardly a going concern. But it's a question of degree as to how far you take it, and also where your vignette starts and stops.
Okay, thank you. Next question.
All right. This is really...
I think we'll just have the three people at the microphone, and then we'll call an end. Yes,
You know,
please
this
go
is-
ahead.
This is really precipitated by a comment you made, Judge Benet, about sometimes the best cross-examination is no cross-examination. And, Carolyn Lamb gave her Proskauer lecture several years ago, and the subject was the decision made by counsel not to call witnesses for cross-examination as being the most effective defensive tool with respect to that witness. And I actually had 3 cases last year where counsel decided not to call any witnesses for cross-examination. And there's a real reluctance on the part of the panel to call those witnesses, even if they do have the power. Many people don't think it's right. You're infringing on a strategic decision. Carolyn, I happened to run into and talk to her. She said she's had the same experience in the last year, and the other co-arbitrators didn't want to call the witness, and sometimes the way the first order is written, you're kind of stuck. Anyway, so my question really for you is, how do you think the tribunal shall handle it? Is that something that should be in the first PO1? How would you handle it as counsel if confronted with that situation? Because I'm seeing it used more and more as a strategic decision by counsel.
Well, isn't it usually covered in the procedural order in the sense that they indicate so many days in advance of the hearing who they want to hear from on the other side? And if they don't want to hear from anybody, it solves the problem, I would think. And I would think it'd be very unusual for the tribunal to say, well, you don't want to hear from him, but I want to hear from him.
Well, that's the point. And it really does change the impression.
Yeah,
one gets.
you're intervening in
I mean,
the
it's almost,
conduct of.
and Carolyn's view that it's almost a violation of due process
Yeah.
in a way, because you're not hearing.
Right.
I don't know.
We've had that come up, and I think it creates a real predicament. I mean, normally the procedural order says that the party, the party who would be cross-examining indicates who it wants to cross-examine. And so if that party, for tactical reasons, says, you know what, we don't want the tribunal to actually hear orally from any of the other side's witnesses, we're not calling any of them.
Yep.
So all you get is the written witness statements and expert reports. The hearing might be, rather short. I mean, you're not taking any evidence, but I often worry that that you really do, that it's almost it benefits everybody in the process, and this is my predisposition, I think, as an American lawyer, to actually hear live from at least the important witnesses, be they fact or expert. So I think that it is a strategy. I think it's a challenging one. It may be prudent if it's emerging more as a trend. It may be prudent for parties who don't want that to happen to them, or for arbitrators who are worried about how they'll decide in those circumstances, to slightly construct the procedural orders a little bit differently, to have more of a residual power in either the party who's proffering the witness or the tribunal itself, in a more affirmative way, to be able to bring witnesses without feeling like you're tilting the scales or changing the rules later.
Any other comments? James, would you be upset at not being called?
Never. I've been more upset about being obliged to fly to Singapore for 5 minutes of direct and 7 minutes of cross.
Oh, frequent flyer points. Next.
Mark, you had what I thought was an interesting comment about often saving questions about credibility for the end of a cross-examination. And I'm wondering, and I ask this generally to everyone, if you have any thoughts about when it's best or most appropriate to deal with issues of qualifications, because that's an issue that's, in some respects, quite unique in the world of international commercial arbitration, relevant to a lot of domestic litigation where the rules of court have a specific section built in for questions about qualifications.
Right. There's not a separate voir dire kind of phase in international arbitration, and you're almost never going to exclude a witness from a tribunal because they're unqualified, even if they are. I think you have to plan. It has to be part of the overall arc. I don't think there's a single answer. It may be that it's so fundamental to kind of lay out from the beginning what the person's expertise is in. Maybe in order to contrast the person from somebody else, another witness who's been called. Or maybe you save it like a credibility attack till somewhat later. What I've found, though, is you have to, the only answer I can give right now is that you have to kind of map out how it's going to go. If you start with that, if you start by a frontal attack on the witness's sort of fundamental qualifications to do this job, what happens to the rest of the cross-examination? It may be that you can make a lot of substantive ground. I think Peter was making this point before, during the cross-examination, because you have good points, especially if the witness is testifying outside of his or her area of competence, for example. Then it's almost better to save it for later, just like the credibility attack that we did in the vignette, because it explains why this person shouldn't be trusted on some evidence that the person's giving that's kind of dubious. So I'm sorry, I don't think there's a categorical answer to it, but I think the answer lies in how you map out the whole of the cross-examination. But maybe others have more categorical or prescriptive answers.
I don't have a more categorical one. My attitude towards it is sometimes the expertise and the approach that the expert takes is a function of the background they bring. And if that background is different, for instance, than the background your experts brought, you may want to focus on it early, because then you're explaining where you see the holes in their approach based on you did it this way because. But I am a big believer in get what you can get from an expert early that's helpful to you, and then make the decision more often than not about whether you really need to beat them up on credibility, or whether they've actually helped you more than that you think they would.
Okay, thank you. I think we're into overtime on the overtime.
Yeah,
So
sorry,
thank you very much. Proceed, yes.
Hans van Houten from Belgium. This cross-examination, which I enjoyed very much, didn't involve much documents to be produced. Mark, I think you mentioned that one should be reasonable and be careful not to produce too many documents or refer to too many documents, because the arbitrators will need some time to retrieve them on their computer. My question is whether, first of all, one should not, for instance, more project documents on a screen. Of course, that has disadvantage that one cannot take notes, but maybe why not return to the old-fashioned paper hearing bundle, but then an old-fashioned hearing bundle which is limited. I was told that in England you can give at New Year a present to someone which he can consume in one day. A bottle of whiskey would be difficult, a small box of pralines would be all right. Now, why not hearing bundles which a person can carry?
Yes. Sounds like a great idea. For what it's worth, we have kind of moved it. We used to use electronic projections of documents like Trial Director and other similar applications. We tend not to now. I think that it's just easier. Some arbitrators, as you know, will have the whole record anyway on their computer or whatever, and they want to keep their own record of it. But I think that's what we do. Typically, what I've seen our own practice being in the last few years has been to return to the old ways of hearing bundles, and particularly ones that are a little bit more focused on, by witness maybe, on what we expect to cover with that witness. And it takes a bit of extra work actually in the preparation to cull it down, but we have a record that's 1,000 exhibits, which is not atypical for our cases, to be able to cull it down to maybe 15 or 20 exhibits in a book and be able to hand out copies of that book. That we've found that right now to be the best way to approach it.
Any other comments?
I was going to say it's surprising by the end of the day in most cases how few documents do matter.
Yeah.
Well, just added to that, I mean, sitting as a judge, we would rarely have a so-called bundle or book of extracts with more than 30 tabs, and yet seems the practice in international arbitration, when you do get these bundles, you get 4 and 5 bundles, of which maybe 6 documents are referred to, and that's why the arbitrators are constantly fishing through these books. They may not even be in the right volume by the time the question is asked and answered. So the whole, well, I'll just give a parting comment that from at least my point of view, focus is what is missing in a lot of these hearings. You're just inundated with stuff. The lawyers are all over the place. Nobody abandons issues because they think even though they don't believe in it, maybe you'll believe in it. And the exercise, it takes a lot longer and becomes much more unmanageable than it should. And I think that's one lesson that maybe arbitrators can learn from courts, even though arbitrators are supposed to be more efficient than courts. Anyway, we have gone well over our time. I'm sure Meg wants to say something, but I would like to also thank council. It's not easy to be called on to demonstrate something badly and then get into an argument of how bad it was. And the expert witness fought his corner and underwent this exercise, and it has been a terrific panel, and many thanks to all of you.